Hello, everyone, and welcome back to another Wisconsin Bankers Association Compliance Corner, this being the August 2023 version. Scott and I certainly hope that you've had a great summer, and hard to believe that we're almost ready for back to school for many of us that are needing to play taxi to the various school drop-off zones here soon. But we wanted to take a little bit of time with you to walk through some of the recent releases by the various supervisory agencies, make sure that you're aware of some new guidance that would be helpful for your institution. So with that, we're going to go ahead and follow our normal practice, I guess, or that we've had here in the last year, where we'll have an agenda and we will have a link to each of the resources that we are going to be talking through today as a reference point for yourself. So with that, why don't we go ahead and jump to our agenda page, and we have some confetti, yay, to share. This is our 1 year anniversary of having these compliance corner videos, and we certainly hope that it's been a helpful resource for all of you. Quick, straightforward, a little bit of a casual flair to it, but hopefully we're able to deliver the information to you and to be of assistance to you and your team on a monthly basis. So we're going to go ahead and talk about FDIC's technical assistance video program. There's a new notice by FinCEN that you should be aware of, as it has some directives for SAR filings and some items to watch for as far as red flags. We have 2 items from the OCCO, legal lending limit guidance and an update on their accounting advisory series. The Fed also has some helpful new guidance as it relates to some novel activities. And then we can't forget the CFPB, of course, and we have some new items there from the CFPB. So without much more delay, let's go ahead and get into it. Scott, I want to refer it to you here.
Sure, thanks, Heather. And as Heather had said, happy birthday to Compliance Corner. We're glad that everyone has joined us for this past year. These videos, of course, being available through YouTube. And on our first slide here, in fact, we see that FDIC has also set up a YouTube channel for their technical assistance video program, as Heather had mentioned. And so what this is FDIC has created a series of videos, and they have a variety of topics and a variety of areas, and they've broken them out into those categories. So they're broken out into categories for bank board members and bank officers and employees. And then they have videos further broken up into topics such as corporate governance, anti-money laundering, fair lending, there's CRA, interest rate risk, cyber challenges, and mortgage rules as well. So there's a whole host of different topics in there, really well laid out, broken out, so you can find what you might be looking for. Those are just some of them. There's many others as well. And these videos then range from a variety of lengths. So there's some videos that are under 10 minutes that are pretty quick hits, but then there are also those up to about half an hour or so. So there's lots of videos in there, lots of information, a lot of different resources and topics that are within there that are worth checking out. So we would recommend taking a look at that. It's in the link below, so you can get it right here in the description below in this video. And we'll also have a link on the compliance section of our webpage as well. So you can find it in either of those sites, of course, just by navigating to FDIC's webpage as well. Next item we have on slide 4 here is a notice from FinCEN. And so FinCEN issued this to bring attention to an increase in state and federal payroll tax evasion and workman's comp insurance fraud in the area of commercial real estate construction. So that's a mouthful. And what's going on here is actually quite sophisticated. And so this is a scheme that involves networks of individuals who are creating shell companies with fraudulent documents with the intent of essentially committing tax evasion and workman's comp fraud. So again, there's a lot of moving parts in this. This scheme is a bit complex. So it's worth reading this notice. The notice really does a good job of breaking it down into steps, laying it out, in simple terms, but also expanding on each step. And it has diagrams as well, which I found really helpful for kind of seeing the various steps and how everything is interrelated and where this scheme typically goes. But to try and summarize what happens for you is that the fraudsters set up a fake construction company. That company and obtain, and again, this is all fraudulent documents as well, right? Shell company. The company then obtains a workman's comp insurance policy, which it then sells to contractors. Long story short with that fraudulent company then uses the funds they receive from the contractors without withholding appropriate payroll-related taxes or paying any of the workman's comp premiums. So again, that's it in a nutshell. It's a bit more complex than that. There is more to it. So check out the notice. It has more details that could help you spot it. But that's the key, is kind of being aware of it and then knowing those steps so that you can spot it along the way as part of your Know Your Customer and as part of your BSA. And the notice not only has great detail and great description of what the scheme is, but it then just lays out bulleted list of 11 red flags that you can use to spot it as well. So there's a lot of those indicators that then, you can work into your procedures. You can train your staff that might be working with these customers so that they can spot. I think there's something here that we need to look into a little bit closer. And then, of course, at the end, it has SAR reporting instructions. So if you do spot something like this, how you can work with your BSA area if it is going to end up being a SAR in order to get that information to FinCEN in the format that they are recommending within this notice. So with that, I will turn it over to Heather to talk about some OCC and Fed-related items.
Super. Thank you, Scott. So first on our short list here is guidance that was issued beginning of the month, that being the 2023-27 bulletin, and we'll provide that resource in the link below for you. It's guidance regarding the applicability of the bank's legal lending limit on its purchased loans. So we feel we have to give a little bit of background here before we jump right into the guidance. But if you think about it, legal lending limit, that is something that the regulators set for our banks, and OCC would certainly be setting that for those institutions that they regulate. And that's going to be the cap, or the most amount of a loan that a bank could be making to any one particular borrower. And makes sense. You don't want to have all of your eggs in one basket to one particular borrower. If in fact that borrower were to go sour, and it would have then a detrimental impact on a particular financial institution. And the OCC's legal lending limit rules are found in 12 CFR Part 32, or what we refer to as Part 32. And within those legal lending limit rules, you'll find a paragraph Q, which has the actual definition for what is a loan and extension of credit. And through that definition, you'll find not only what it is, you'll find some pretty straightforward nitty-gritty types of calculations that you use to identify how much is the outstanding amount to one borrower. But where this guidance details or pinpoints into on this topic is when the bank purchases from third parties paper. And those arrangements oftentimes have agreements that the seller of that third-party paper may be required to repurchase that particular loan in certain default situations, or there might be a limitation to what they're actually repurchasing, but it's those types of contractual requirements that the seller has to the to the bank of that bought paper that you really need to look at closely to see whether or not there's any kind of recourse back to that seller. If there is no direct or no indirect recourse back to that seller, then you don't have to count that particular purchase loan as being attributed to that one seller. If you do have recourse back to the seller, then you're going to need to bundle all of those purchase loans together and treat it as all one loan being made to or being held by that seller, which could very quickly, unfortunately, bump you up against or over the legal lending limit, considering that seller being one borrower. So the guidance really looks at that particular small scope, that they're trying to remind financial institutions to watch those third-party seller agreements. And you're going to want to work very closely with your accounting firm and with your counsel about those specific language pieces to really look at whether or not you have a direct or indirect recourse back to the seller who sold those third-party papers to the bank. The guidance does talk about how that recourse could be explicit or could be implied. So again, really close detail to the contract language. This unfortunately has been a problem for some of our financial institutions here in Wisconsin. Certainly very legal to purchase third-party paper. It's just you have to be very careful about the contract terms to make sure that there isn't an aggregation of all of those loans purchased from that third-party seller to that one seller from a borrower standpoint. So again, work very closely with your counsel on those language of the particular contract. The other item that we wanted to make sure that you were aware of was an updated bank accounting advisory series. No new regulation is being released. It's just that there's some updated FASB standards that have been incorporated into this particular guidance. So you'll want to make sure that your accounting area is aware of that new guidance and some of the nuances that have been added into the frequently asked questions of that. So as Scott mentioned, we also have some guidance from the Federal Reserve. And again, we've provided you a link to the actual release of this announcement. But what it does is this announcement has two different resources, two supervisory regulation letters, which we've noted here for you. As the Fed has tried to create a new program where they're going to closely examine what they're calling novel activities, primarily being digital assets, blockchain technology, crypto assets, because they know that the banks are wanting to provide certain services to their customers. And this is their structure for how they're going to monitor that new activity, as well as some steps that you would have to take in order to gain the AOK, basically, from the Federal Reserve, where you'd have to be reaching out to your supervisory examiner and say, this is what we hope to do. We've identified these risks. These are how we're going to monitor those risks, both initially when we launch and ongoing as we continue to offer that particular product. That's this kind of guidance. So you're going to want to work through that when you are wanting to offer crypto asset technology or blockchain technology for your customers. It doesn't identify every single risk, but I would certainly make sure that in your ask of the Federal Reserve that you incorporate all of the risks that they've identified and then some, so that they can fully assess your program, your process through their new supervisory program itself. Scott?
Yeah, thanks, Heather. So for our last couple slides here, we just have two items from CFPB. And the first one is a link to updates for our 1071 rule. This is just the 2024 filing instruction guide for submission of data. So you'll find in here details regarding file format, overview, data points, and validation. Again, depending on whether those of you might be required to file for the 2024 period here. CFPB, of course, acknowledges what I'm sure is on everyone's mind right now regarding this particular topic is the court case out of the Southern District of Texas, in which CFPB was ordered to not enforce the rule against the plaintiffs as named in that case. We've, of course, been tracking this, reporting on this. I'm sure all of you are aware of this. The result of the case, though, currently being that it only applies to ABA members. And so the most recent step then, the development there has been an ask from the industry to delay the rule, Section 1071 implementation for all lenders. So outside the scope of just that court case of the plaintiffs in that court case. This is a direct ask from the industry. So it comes from including Texas Bankers Association, ABA, and a letter from all state banking associations as well. And this went directly to CFPB. So we'll continue to monitor and report on this if anything further develops. But in the meantime, it's still wise to assume that the rule is otherwise on track for purposes of implementation. The last item we have here is a news brief that CFPB issued regarding action that it took against a mortgage company for providing legal kickbacks to real estate brokers and agents in exchange for mortgage loan referrals. We won't go too much into the details on this. The news brief is in the description below, so certainly read it for more to get more of those specific details. But we wanted to include it and discuss it here as part of the video because CFPB is still vigilantly taking action against RESPA violations, something we've been talking about for the past year or so. CFPB has put out various pieces on it, including a recent FAQ on Section 8 violations. We know that many of you have been contacted by various settlement service providers or otherwise seeking ways to engage or promote with methods that need to be reviewed under RESPA Section 8 and those prohibitions therein. So just continue to be aware that the agencies are taking action in this area. Review those types of arrangements that you have or you might be looking at or requests for. Again, CFPB has a decently helpful FAQ out there. So I find that that's a good place to start or a good refresher if it's something that you haven't looked at in a while. But always make sure that you're consulting the rule directly, the rule itself as well. And to wrap up, don't forget that we have many resources available for you on the WBA website and our compliance webpage. For example, we talked about a fraud scheme today that FinCEN put that alert out on. And so just to focus on that as an example, WBA has a financial crimes committee, which meets regularly throughout the year. And part of that is discussing fraud schemes, such as that one, such as what FinCEN put the alert on, and others that we've talked about. And so there are resources from that group within the best practices library, for example, that you can find in there and use as needed. But that group also puts out fraud reports, which go out in the Wisconsin Banker Daily. So similarly to how FinCEN puts out its notice, we have our own group that when they see those particular schemes or things that are coming around, we make sure to make the membership aware of that as well. So make sure that you're checking the Wisconsin Banker Daily, that you're signed up for that and getting it. As we had mentioned last month, we're very happy to have available to you for you our account titling video series. And so within this series, you'll find over 5 hours of video content, a whole host of written content to accompany that as well, broken out into topics and laid out all within the context of account titling. So again, that resource is there and available, and we're very happy to have that. That's on our website. So if you want to know more, we've got a page for it, or you can certainly reach out to myself and Heather as well, and we'd be happy to tell you more about that resource. We've also launched our in-house compliance training, where Heather and myself are excited to have the opportunity to come out and work directly with you on training topics of your choosing. We have a list of potential ideas that you might pick from, that you might see as an area or a topic that you want to explore further. And that would be an opportunity for us to work with you either in person, directly at your bank, or virtually, as you prefer. So again, check out the page on that. Take a look. If there's any topics that you have in mind or you just want to know more about what that's about, don't hesitate to reach out to us. And of course, don't forget to call or email us through the legal hotline. And thank you for joining us during this first year of Compliance Corner. And with that, we will wrap up.